weeks ago. This case went to trial, what, about 3 weeks ago, John?
That's about right.
And,
yeah, 3 or 4.
Okay, and the Saturday before the trial started, this was in federal court in the Western District of Michigan?
That's right, a real conservative jurisdiction. Dan, you know.
Judge, right?
What's that?
You had a liberal judge that was very friendly to your case?
No, we had a Bush appointee who's the only judge in the particular courthouse. So it was kind of his kingdom, and very conservative, very conservative.
And did that affect the presentation of evidence?
It affected a lot of things. I mean, by the time we got to trial, I'll tell you about it, but we had about this much of our claims left. We had like half of a single claim for excessive force. So everything else went out the window. False arrest was gone. Malicious prosecution was gone. And then most of our excessive force claim was gone on qualified immunity. So we just were hanging on by the hair on our chinny chin.
Yeah, this was a challenging case to say the least. In fact, and Dale, just tell him, Dale, you saw this case, you're like, well, it's good for reps. Not good for the bank account, but good for reps and mental toughness.
That's true, but I must say, first of all, I had a lot of faith in John. In meeting John, I knew he was going to give the client the best shot at prevailing, and I honestly am not surprised that he had a good result because he was very prepared. He really knew the issues. I hope I was able to help in some small way, but I'm really happy for it. And I think I'm really happy, Dan, you're doing this case today because many people have small civil rights cases and many people have conservative venues, difficult judges, a client intoxicated on drugs or alcohol or doing something stupid. And many of them have had most of their claims wiped out. So this is a great example of how you could even take a case like that, still apply the basic principles and prevail for the client. And the same principles that apply to this case are going to apply to a wrongful death case or catastrophic injury. So this is all good stuff.
That's a great point, Dale. And the fact too that, John actually got to trial. I mean, most of us have not even had the opportunity to get to a trial in over a year. And so to get up in a courtroom and tell a story and pick a jury and present evidence, no matter, honestly, in my opinion, no matter what the result, is such a valuable experience to, get the ring rust off, get your flow back, really get your confidence back because it's such a confidence game. And so, so John, before we get into the details of the challenges of the COVID experience and whatnot, and how that may or may not have affected your presentation, why don't you give us an overview of this case so that we can all understand the story, and then we can talk about some of the challenges that you faced and how you went about preparing for those challenges.
Sure. So this is a civil rights case arising, it's 2014. It was an old case. August 30th of 2014. My client's name was Jason Banas. I'll show you a Mr. Banas and his family. This is Mr. Banas right here and his late father. Jason's a middle-aged, 30-something. I think he was about 35 years old at the time. And he was a sports fanatic. So Jason loved to go to football games. He was a Michigan State alumni, went to Michigan State. His whole family went to state. And this guy's passion was to go to sporting events. And on August 30th, 2014, Jason went to the Michigan State football game. They were playing Jacksonville State. And like thousands of other people, he drank and he got drunk at the game. He got drank before the game. He drank after the game, and he got pretty lit up.
Well, John, I like to just say, I think the video will show, which I know you're going to show later. He was real drunk.
Yeah, and you remember he drank during the game too, John. This wasn't, he didn't stop drinking. Let's put it that way.
He did not stop drinking. He was wasted, but you know what? He did so responsibly to a certain extent. Remember, this was 2014. He knew he was going to be drinking. He had his buddies pick him up, and he hitched a ride to the game. He didn't drink and drive. He wasn't going and doing goofy stuff. He wasn't picking fights. He wasn't doing any of the bad stuff that we automatically associate when we think about somebody getting blitzed and getting in an altercation, right? And so he went to the game. After the game, he went back to his buddy's house. And at about 1 a.m, Jason's diabetic. So he couldn't spend the night. So that wasn't an option. That was an option that was taken out because he had to get his insulin. And so like at 1 a.m, he says, well, I got to get out of here. And he calls a cab. This was before Ubers and Lyfts. So he calls a cab, and this is East Lansing after the home opener at 1 a.m. There's no way he was going to get a cab. They told him it would be about 2.5 hours. And Jason said, 2.5 hours. Well, my house is about 3.5, 4 miles from here. I run this route all the time. He was a big runner, so he knew exactly where he was, how to get home. And he said, I'll just walk. It was a nice summer night in Michigan. And so he decided to walk home, and he made it most of the way there. He made it about 3 miles, and he had about 1.5 miles left to go. And he entered Meridian Township, where this event happened. And that's where he encountered the defendant, Officer Hagbom. It was a quiet night. There wasn't a lot going on in Meridian Township. And this officer didn't have much to do, so he stopped Jason.
So what time of the morning is it that he stops him, John?
It's close to about 2 a.m. at the time. So, and I'll show you guys the video that, because a lot of this was caught on the officer's dash. So let's go ahead and take a look at this video together.
This is testing John's technological skills, which is everybody should be nervous right now, because I know I am. God knows I am. All right.
All right. So this is the view from the defendant's dash cam. So, you know, this is affixed to the front of his vehicle. This is Meridian Township. This is by a golf course. It's not like a high traffic area. And what was really important, and what we really had a hammer in this case, was Jason didn't do anything wrong that led the officer to stop him. So a lot of times you'll have police cases where somebody's getting in a fight, they're harassing people, maybe they're even committing a crime. That wasn't the case here. There wasn't, he didn't violate the public drunkenness laws because he wasn't harassing anybody, and he wasn't in the middle of the street. He wasn't, you know, nobody called the cops on Jason. This officer was just driving around. And the officer's testimony was that he saw Jason, who was just walking on the sidewalk, he wasn't in the middle of the street or anything, fall over, and his falling over caused the officer to stop for his safety. So the whole officer's story was, this was all for Jason's own good. We stopped Jason for his own good, and then eventually it shifts into, I body slammed him into the ground for his own good. I got on his back and broke his rib for his own good. And I pumped him full of 50,000 volts of electricity from my taser for 10 seconds. But this was all for Jason's own good.
Can we see the video, John, so that we can, you know, have the objective evidence?
So this is the officer. There's Jason right there, right there. The officer does a turnaround. He does a drive-by again. And then you're going to see he does another turnaround. He drives by Jason again, and now he goes to engage. And there's Jason. He was bending over to pick up his cell phone.
Yo! Police!
Now, one thing, if you notice, this is the defendant. So this is the defendant police officer. He comes across in his deposition, and you're going to see very well. One thing that we picked up on the focus group is one of the first things he does when he gets out of the vehicle is he puts on his police gloves. As you notice, like normal police officers, he has his gun. He's quite a bit bigger than Jason.
Where are you going, man? Worst home for you, because you're super drunk. You just fell down.
That's fine.
Okay. Where do you live? At least I know you're going maybe the right direction or something. You don't know where you live?
I know where I live.
Where do you live? I'm not trying to mess with you, man. I gotta make sure you're okay. I have contact with you because I just saw you fall down. What's your first name, partner?
And so Jason's, really non-responsive. I know it's tough to hear, but he's pretty drunk. He's not really answering the officer's questions. And most people who see this video from our focus group and I've showed this video to about, 100 people. The officer comes across as pretty nice originally, which was a challenge that we had to deal with in the case.
Hello? What's your name?
Jason.
All right, Jason. I'm Officer Hagbom. Like I said, not here to mess with you. But I saw you stumbling, and then you just fell down. Hold on, you're not going anywhere yet. Hold on. All right. How much did you drink? You think a little too much?
No.
Okay. Well, do you want me? Why don't you sit down over here? I'm going to help you down real quick.
No, sir.
Okay. I had contact with you, okay? I got to give you PBT and make sure you're not way too high. All right?
Okay. I don't mind.
Okay.
Yeah.
All right. You want to stay like that, or do you want to sit down?
You're okay.
Okay, like that?
Yeah.
All right. Stay like that. Because if you're really super high, we'll have to give you something, but... See where I put my PBT again. There it is.
So, and the officers testified that at this point, Jason wasn't free to leave. He didn't commit any crimes, but he was there for his safety. And there's a exception to seizures called the community caretaking exception, which, is generally like, if a police officer peers in your window and let's say you're passed out in your living room, they can break in and do a warrantless entry to basically give you aid or help. And so the defense in this case was, even though Jason didn't commit any crime, the officer had a right to stop him and detain him pursuant to this community caretaker exception to make sure that he was safe for his own good, basically. And that was the justification for the stop. And as you're going to see, he gives them multiple PBTs. Now, in Michigan, there's no obligation to take a PBT. It's not illegal to refuse a PBT unless you're driving a vehicle.
Like I said, you're not in trouble with me, but I got to see what your intox level is. Make sure we don't take you to the hospital or something like that.
Yeah, but I'm kidding.
Okay.
Don't worry about it.
All right, cool, man. Have you taken one of these before, or know at least how to take one of these?
I don't know what you're talking about, Carl.
PBT? I guess got to see how drunk you are.
No, don't worry.
What?
So don't even worry about it.
I need to give you this because I contacted with you. You're falling, so as long as you don't blow over a 3-0, I can let you go home. But if you blow over a 3-0, you gotta go to the hospital. All right, so take a deep breath in and blow till you hear the beep. Okay? You see it right in front of you? Open your mouth. Open your mouth and blow. Go. Blow. More. Harder. You gotta do a little more than that, man.
There you go.
All right, deep breath in. Blow hard. Go. All right. You know how to blow a balloon, right? Deep breath in. You got to blow out for like 10 seconds.
That was close enough.
You're not.
So Jason's tried the PBT about 3 times, and for whatever reason, it's not registering, you know, whether it could have been a bad unit, it could have been he didn't blow long and steady enough, it could have been he blew too hard, but he gets kind of fed up and refuses to blow again.
Close enough. I didn't read it.
Well,
All right, deep breath in. This is the last time. If you mess this one up, I'll have to assume you can't blow and you can't walk, which means you have to go to the
wait,
hospital.
sorry, what are we doing?
You gotta take a deep breath in, blow out for 10
What are
seconds.
we doing?
It's PBT.
Okay.
Deep breath in, blow. Harder, 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 harder. All right, I'm gonna do a manual test on you because
You were walking home. What's the problem? I was walking home.
hey, you're a danger to yourself when you're
From
falling.
where? I was walking home.
You fell down.
I fell nowhere.
Okay, I saw you fall.
Where? From
Right
where?
here. You just fell.
From where?
And now you're gonna see Jason and the officer appear. So Jason wanted to show the officer that he was okay to walk home because he had made it most of the way. His house was like straight ahead on the street. I'm gonna show you a map that we use in our opening to help give a visual. And he wants to show the officer, you know, just like you do in a sobriety test, that he can walk a straight line and that he's not falling. So that's what you're about to see. And it's important to put it in context because, you know, there was no allegation he was trying to run away or anything like that.
Okay.
So where? I was walking home by myself. No.
Last dance. Deep breath
Get
in.
this out of here. No, I wasn't going to do this. None. I was walking home.
Okay.
I was walking home.
Hey, John.
Okay, you're
can you
falling,
stop
dude.
this
You're too
for-
far.
Where?
You fell off the.
What'd
One
you
of
say?
the points I want to make here, because I was able to watch the video with John and Dan when you know, we were talking to him, helping him to get ready for his case. And up to this point in time, obviously the fact that he was intoxicated is potentially a difficult fact, but in a way you can almost make it a positive fact for you. Because if the officer was supposed to be there for his well-being and was allegedly concerned about his safety and thought he was intoxicated, that some people might suggest are more vulnerable, he thought he was stumbling or fell down, even though that was disputed. It's great to point out with the officer or an expert, like when you're watching the video up to this point in time, had he verbally threatened you? No. Had he used any profanity? No. Did you see any weapons? No. Did he try to punch you or kick you? No. Did he run away? No. Did you think it would be appropriate to use force on him up to this point in time? No. You thought he was intoxicated, correct? Yes. You were concerned for his well-being. Did you think your job as a police officer was try to protect him at that point? Keep him from injuring himself? You kind of set it up in the jury's mind. Well, what happened in 5 or 10 seconds that you're suddenly, you know, going to injure this guy? And so I thought this part was very important, even though he's obviously slurring his words. And even though the officer was nice up to this point in time. And I agree with you, John, that's a challenge when you have a nice officer, right? Nice in front of the jury, nice at depo, nice on the tape. But all of that's about to change. And I think what's coming up is the most compelling part of the case. So I just wanted to throw that out there. Sometimes in establishing a timeline in the jury's mind, well, it wasn't okay to use force all this time. What happened in 5 seconds? And then the concept of escalation, de-escalation becomes very important. Who escalated this situation? Arguably the officer did. So I just wanted to make a few of those points.
Those are great points.
Yeah, Dale.
Go ahead, John.
And one thing that we talked about when we kind of discussed this case and roundtabled it all day on that Saturday before trial, which was really helpful, was a point that you made about, you know, their whole defense is Jason wasn't compliant. He wasn't doing what the officer was ordering him to do. But the flip side of that is all the ways we can point out that he was compliant in both my opening and on the cross-examination of the officer. He told the officer where he lived. He tried to blow in the PBT 3 times. He tried to show the officer that he was safe to walk home. He didn't just start running away. I mean, there was things that he was doing, especially at first, in order to attempt to comply with the officer until it became apparent that he wasn't going to be able to leave. And for a guy walking home in the middle of the night by himself to have an armed officer approach him in that drunken state, and all of a sudden he's having this breathalyzer shoved in his face when he didn't do anything wrong. People could be startled. People could be upset about that.
That's really good. Oh, go ahead, Dan.
Clayton Robertson had a question I thought was a good one, is that if the officer, had just let this person go, knowing clearly that he was visibly intoxicated, and this guy stumbles into the street and gets killed, does that officer, his agency, have any liability?
Yeah, that's a great question. I think it depends on your jurisdiction. Generally, under federal law, no. There's what's called the public duty doctrine, which says that the police do not have a general duty to the public in general to protect them. There is a doctrine called the state created danger, but at least in the Sixth Circuit, that theory is very limited. And the state created danger says if a police officer does something, takes an affirmative act to increase your danger, then they can be held liable. So for example, if they pulled you over for drunk driving and then left you in the middle of the woods, they took your vehicle, impounded it, and then left you in the middle of the woods, you could conceivably have a state created danger claim. Like, let's say it was the middle of winter and they took your vehicle or shelter away from you and then threw you into the snow. Then they increased the danger to you. In this case, at least in Michigan and in Sixth Circuit, if the officer saw a drunk guy and said, I just don't want to stop, you would have a very difficult time to bring a case, in my opinion. However, certainly these are considerations, and that made it more complicated because the defense in this case was he was just trying to be a nice guy. The officer was just trying to help this guy out, which is something we had to deal with.
So Dale, is that accurate?
Yeah, a couple of quick points. First of all, the response by John reminded me of a case I'm working on now where they detained and handcuffed a person, put him chest down in the middle of an intersection, and lo and behold, he gets run over by a car as he's sitting there chest down in the middle of the intersection. But in any event, the other point is sometimes if someone's really intoxicated, I asked the officer, you believed he was extremely intoxicated. Yes, I believe so, in part because he was slurring his words and you thought he was stumbling, etc. And then a few follow-up questions to use it to your advantage. Were you trained that someone intoxicated may have difficulty understanding commands? Were you trained that someone intoxicated may take longer, that he might have had balance issues, that he might be more vulnerable to falling down? So when you get all these things, any hesitation in compliance or when the struggle happens, you're dealing with a guy you knew was intoxicated and based on your training, you knew was very vulnerable to injury. So what in the heck are you doing all those things you did to him? The other point I wanted to make, and we talked about this in the show, in shows I've done with Dan in the past, framing the case, right? The question is, a lot of jurors will understand why the officer stopped them in the first place. And you don't have to go there because that claim was already, adjudicated. Your thing is to the jury, you don't have an issue that the officer stopped him to see if he was okay. Your issue is that the officer didn't need to seriously injure him. And so the jury will get that distinction. And one other thing I think we talked about, John, was at some point the officer, I think, offered to drive him home. I don't know if we heard that yet. And I think he politely declined. And I told you that might be an issue you have to address at some point.
Yeah, it definitely was an issue. It definitely hurt because a lot of people said, you know, one thing that we look at, Dale, and that you recommended is, what are the other things the officer could have done other than body slamming him, other than kneeing him, other than tasing him? And, you know, one of the things that is very readily is give him a ride home. But, you know, he offered that. Jason said no. So that took that out of the other options. But there was other options that we looked at. You know, why couldn't he just wait for backup? Why couldn't he wait for an ambulance? Why couldn't he just stand there and let things chill out for a couple minutes? You know, why couldn't he follow him in his car? You know, some people might say that's crazy, but there was other things he could have done other than doing this. And one of the things that the jury said is, you're going to see the use of force. The officer justifies his use of force by saying that Jason would not move where he wanted him to, and that Jason tried to sit down. And one of the things that we argued and that one of the jurors really stuck with was, the guy's trying to sit down, why not just step back and let the guy fall on his butt on the cement? But the idea of always look at what other alternatives did the officer have, Dale? And that's something that I think I learned from you that was extremely helpful in this case.
Okay, good stuff.
All right, so here's the
sidewalk.
Where did I walk home? Where did I fall from?
Where are you going? Do you know where you
I'm
can't?
walking home. 523 Bainbridge.
Where's Bainbridge at?
Bainbridge, straight ahead of here.
And you can tell the officer, his patience is now running thin. And that was one of our, as Dale, as you pointed out, we didn't contest the initial stop. Part of the reason because the judge kicked it out. But what we contested was the ultimate use of force and how much force was used. And if you listen, the officer, who was originally very patient, you can tell he's starting to get mad that this guy isn't doing what he wanted him to do.
523 Bainbridge.
Okay.
Walking home.
You want me to drive you home?
No, I wouldn't let you do. I'm walking home.
Okay. I can't leave you.
I apologize to you. I don't know what it is, sir. I don't know what you...
Dude, I gotta make sure you're okay.
I'm walking home.
So take this PBT so I can let you go walk
No,
home.
I'm not taking any PPT. No, none to man. No chance. None. I apologize. I'm walking home.
You got second unit close so they can
I'm
have this
walking
way.
home.
He's
Walking home.
Okay.
Sorry. No offense to you. I apologize.
Dude, you can't be falling over.
I'm not falling over.
You fell over. Hey, hold on.
How is this? Am
Stop.
I falling over?
Stop.
I'm falling over. I'm falling over.
See, so right there, Jason was attempting to show the officer he's not falling over. He didn't fall over. He had no injuries on him at the time, by the way, like when the officer stopped him. And he's trying to show the officer that he could walk. And it's a good thing he did, because otherwise we would not have video of what happened next, of what is about to happen. But this was kind of a turning point in the encounter. The officer, who's been becoming increasingly impatient with this drunk individual, when Jason walks here, this is where things kind of reach a boiling point.
That's a straight line.
And if you notice right here, this is where the officer now physically grabs him. So this is the initiation of force moment. Okay, this is the first time that physical force is used, and you're going to see it escalates rather quickly. But at this point, the officer made the decision to use force, and that he was going to use force if Jason didn't do what he wanted him to do.